This next set of questions deals primarily with the arbitration and mediation process. Let's start with this one about who should write up the settlement. And this is good because it reinforces that the mediator really should not be the primary drafter. Again, particularly if the parties are not experienced, then there gets to be confusion over whether that person is an advocate or just a scrivener. But this question is well phrased and asks, how are the counsel selected? If things have gone really well, there is usually a trust factor that the parties now have in counsel. And sometimes a party will even agree to let his or her adversaries counsel draft it, or let's take the very specific question asked here. If there are multiple parties involved, it's probably going to be the joint process between the two primary parties. If it's an owner and a GC, their counsel are probably going to do the significant drafting. But the mediator, this is where the mediator's role is important, is going to help in crafting a process to make sure that the counsel for the lesser parties, and I don't mean that they're less important, but just probably had less of a role, a smaller claim or smaller defense, but that mediator is going to help facilitate a process whereby which the primary attorneys are going to write up the settlement agreement, and then there's going to be a comment and revision period and getting it back to the counsel who drafted it, getting everyone to sign it. Having a time frame for doing this is crucial, and this is where it's good for a mediator to be checking in periodically. But again, if they've gotten this far and they've reached an agreement, parties are going to have to take that extra leap of faith. There's no set formula. And if there is a lack of trust issue, maybe they have reached a settlement, but it was tough getting there, then the mediator is probably going to insist that a large part of the content of that settlement be drafted before the parties leave the room. And it's going to be, as we discussed earlier, some sort of memorandum of understanding or agreement where the real nitty-gritty details are hammered out before anyone leaves. That way you can't go back to the home office and start changing things and allowing the process to break down. I want to address another question raised here. Counsel are never assigned to the parties by AAA or JAMS. Parties come with their own counsel. It is not a role of any of the ADR providers to offer an advocate. That breaches their duty as a neutral ADR provider. At best, what they could do is give the parties some resources. I know in the past I had referred people to their appropriate state or local bar associations, which often have referral procedures, but it is never the role. And it's also never the role of a third party outside counsel. It's going to be one of the attorneys in the room, or multiple of the attorneys in the room. And then this final point, if the mediation is settled, then the mediator is done. That office is closed and over, and there is no further role for that mediator. Now, I have seen settlement agreements where the parties have written the mediator with his or her permission, although occasionally without, but the better course is with, to say if this new contract that has resulted from this settlement, if a dispute arises under it, then we reactivate this mediator for any new disputes and go back to the clause drafting materials. It would be that same sort of mediation clause, except they might write in this specific mediator because he or she has the knowledge of the parties. That is rare, though. What really happens in most cases is when the parties write up the settlement agreement, they make it into a contract and they put in a new dispute resolution clause with a standard mediation provision, and it does not name a specific mediator. In fact, some mediators would refuse. They would say you would be better off going through the selection process again, because the dispute that arises from the new agreement might be unrelated to this agreement, or you might just want a fresh start with somebody else. But this is a good question. It really gets into the mechanics of how things are done. So I hope that clarifies it. Let's stay on mediation for a minute here. This gets a little tricky. The mediator never really becomes the arbitrator midstream. I suppose it's possible, but if the parties are not able to settle their dispute, that's it for the mediation. They hopefully have another step in their process, either arbitration or litigation, and they will just go to that process, usually with a new neutral. I suppose there is the rare possibility where the parties like this person, they have faith in him or her and trust, and they've gotten past the confidentiality issues. But go back to the reading in the Edna Sussman article. If the parties tried to convert this neutral into an arbitrator to render a decision, and then one party was dissatisfied with it and tried to have it vacated because there was not that process of informed consent before the proceedings started, they might have one of the rare winning arguments to vacate, in that they weren't quite sure what they were doing when they entered into this process. And then looking at a court mediation settlement, sure, courts refer parties to mediators all the time, but again, it's a separate and distinct person. It's not the judge who's going to decide the case who's going to mediate it. Although some try to. It's rare. They don't even want to be doing that in most cases. A good judge isn't going to want to be the mediator, and really ethically can't. So there really isn't much of a difference between a party agreed upon mediation and a court ordered or court referred mediation. And the parties, again, are always free to go off on their own and negotiate, regardless of what proceeding they're in. And that's really the best case, if they can settle it on their own without a third party. But going back to the initial question, if the parties can't settle with the mediator they're with, they either need to get a new mediator or go to the next step in the process. And staying again with mediation, under the Massachusetts statute, this is correct. The information in the mediation cannot be revealed by the mediator. That mediator can't be called as a witness at trial. Nor can the parties agree that the mediator's notes can be put into trial as evidence. No mediator would serve on that case. They would probably never be picked again if they agreed to do that, because that just destroys the trust that any future parties would have in the mediator. So to the question of can it be subpoenaed, no, it's protected by that statute if all of the qualifications of the statute have been met. If that mediator has had the requisite hours of training, if the parties are using rules or have specifically cited this statute, then the protection applies. But the parties can't waive a statutory confidentiality protection. Good question, because it's a good issue to think about. You want that protection there. Now, moving on, this next question states that the arbitration process is the most efficient out of all the ADR options. I'm not sure I would agree with that. It might be more efficient than litigation most of the time. It should be. My personal view to share with you guys is that it's not more efficient than mediation. But let's get to the meat of this question, the arbitration process and reasoned awards. Again, this goes back to something we talked about earlier. Because this is a private process, there are very few sources of information that fully collect this information. And to the extent they do, they really don't drill down to this level. And again, remember that arbitration awards are not appealed through the court process. The only way they can be appealed in the fuller sense of the word, exploring whether or not the arbitrator made an error in fact or law, is through the arbitration appeal process, the rules established by JAMS and AAA. If the parties are in court after an award, it is on a motion to vacate, which is not the same thing as an appeal. And the statistics on how many cases are vacated, I have not been able to find anything that parses down to the level of whether or not there was a reasoned award. There is a great perception that if there is a reasoned award, that parties are going to be able to use that to establish that the arbitrator had a bias, which is one of the statutory grounds for vacating an award. But if I can come up with some more recent data, I will try to share that before the end of the course, but everything that I have available is getting fairly dated. This relies on the parties participating in surveys most of the time to get this information. This is a very important question because the dispute usually is not just between two parties. It usually there's a flow down through the contracts. Again, a sophisticated, high dollar value project, parties and their counsel who write the contracts are going to think about this and have consistent ADR clauses all the way through. Probably the more common case, what's in the subs contract is not the same as what's in the owner and GC's contract, and you can have different proceedings going forward and potentially different results. Arbitrators' powers are somewhat limited. In the AAA rules, read R7 again. The parties can agree by incorporating those rules to give a special arbitrator the power to review whether or not a new claim should be brought in from a different set of contractual relationships. But that arbitration clause must be there. The arbitrator does not have authority to join a party who does not have an arbitration clause. So this is very important to know, and as parties go through the contracting process downstream, they really need to make sure that there is some level of consistency all the way down the chain of contracts. Now, this doesn't mean that a party can't seek to have an arbitrator join a party without an arbitration clause. Usually that party is going to fight it. They just don't want to be dragged into a bigger proceeding. Once in a while, they might come in by agreement. And occasionally an arbitrator may overstep his or her bounds and say, yes, there's no provision for any dispute resolution in that subcontract agreement. I am ordering that subcontractor come into this proceeding. The subs attorney is going to go running into court and fight that, and more likely than not, the judge is going to follow the contract language. The judge may strongly advise and encourage that the sub join the arbitration because it's going to be more efficient, and there will be a long lecture most likely on the chance of inconsistent results. But I suppose there's a judge out there who might support it, and that could be an appealable judicial decision in the court system now. But this is very important. So as you're writing contracts or involved in that process somehow, make sure that the consistency of procedure flows all the way through the contract chain. How often are cases successfully resolved through arbitration or they go to litigation? This turns on how you define what successfully resolved means. All cases that go to arbitration that do not settle are resolved by an award. So they don't go to litigation. Again, there is no right of judicial appeal in arbitration. As far as successfully resolved, getting the case done, getting to arbitration, getting an award, moving it off the books and on to the next project. Again, all cases that go to arbitration that don't settle get awarded. So they're resolved. If a party's satisfied with the process or not, that might turn the question of whether it's successfully resolved. If there was an award the parties are happy with, but it was an expensive process, that's probably going to cause them to rewrite their arbitration contracts for the future.